look good. All right, great. Good afternoon. Thank you so much for being here. I apologize for being a little late. We were stuck in an elevator, but we finally made it. Joining me today for today's announcement is the New York City Department of Investigation Commissioner Mark Peters. From the NYPD, Chief Brian McCarthy, who is the commanding officer of the Criminal Enterprise Division, and from the Manhattan DA's office, Assistant District Attorneys Guy Tarandico and Denise Vizel, who were responsible for presentation of the case in the grand jury, Judy Salwin, Deputy Chief of the Rackets Bureau, Jody Kane, Chief of the Bureau, and Mike Sachs, Chief of our Investigation Division. This afternoon, we are announcing the indictment of a group of individuals and companies that maintained a violent, corrupt, and nearly complete monopoly on New York City's towing industry. Now, being involved in a crash is something many of us have experienced, and it's often a scary thing that can happen to you almost anywhere. So most people don't think about the specific details about what happens next. They're just grateful that somebody showed up to help tow the car. But if you were involved in a collision in New York City between June 2015 and December 2017 and received assistance from a towing company, you were most likely an unwitting customer of an illegal enterprise that dominated New York City's towing business and is the subject of our takedown today. As alleged in the indictment in this case, which I hope you'll be able to get copies of that indictment, 17 defendants and 10 companies, led by Dan Steiniger, worked in concert to maintain and enforce a fraudulent monopoly in tow work in New York City, in the kind of industry racket popularized by films years ago, like On the Waterfront. Today's indictments, of which there are 4, allege various schemes the defendants used to enrich themselves and exert control over the industry. The first scheme focused on establishing dominance over New York City's streets. Currently, when a collision takes place, the responding NYPD officer checks a rotating roster of towing companies that are eligible to perform jobs in certain geographic zones, and then summons one of those companies to remove the disabled vehicle. That rotation program is meant to ensure that towing jobs are divided up fairly and equally. In order to get as many spots on that rotation list as possible, the defendants, under the direction of Daniel Steiniger, fraudulently acquired and consolidated various other towing companies and then stacked that roster with multiple companies that he controlled. The companies had different names, the companies had different logos and listed owners, but they were, in effect, fronts and shell companies for the Steiniger enterprise. Now, for example, when a tow job was required, the first company summoned to the scene from a rotating roster might be Daniel Steiniger's company. The next company on the rotation might, however, be registered to his sister, Karen Steiniger, and the next company after that be registered to another co-defendant, and so on and so on. And in that manner, they were absorbing the greater part of the tow jobs that were called in by the police. Now, beyond the surface problems of shell companies, these companies were often barely operational. To my right, you can see an overgrown service yard. It was taken at a location listed as an active tow yard in the Steiniger conspiracy. This scheme was all about having the appearance of competition. Sometimes the defendants disregarded the rotation program altogether and engaged in an incredibly unsafe practice known as chasing, which meant listening to police radio chatter, identifying collision sites, and then barreling their trucks to the scene ahead of the competitors. The first to arrive there usually got the job, which is why the defendants made special efforts to snap up lucrative specialty jobs before their rivals. This is referencing what they call heavy towing duty. Now, in these heavy-duty towing collisions, there's actually a lot of money at issue. Tractor trailers pulling them out from bridges, unloading the cargo and taking it for repairs brought as much as $40,000 to $50,000 per tow job. So there was a huge financial incentive to beat out competitors. And in several instances, the defendants used simply violence to maintain their dominance. If a rival company arrived on scene at the same time as one of his companies, Daniel Steiniger encouraged his drivers, and I'm quoting from eavesdropping warrants, show some force, cause a ruckus, And you'll see to my right also several pictures depicting the sort of force that was at play here. One in the middle, an individual with a baseball bat, and the other on the far right shows damage to a competitor's truck. And the defendants called this blasting, which meant striking a rival's tow truck with a crane as a warning or an act of retaliation to make sure that the competitor company did not get the job. So the first scheme we talked about was how they achieved dominance over geographic locations. The second scheme involved the right to perform what are called arterial tow jobs on city highways. Now, unlike a regular city street, towing on a highway requires an exclusive permit, which is overseen by the NYPD. As in the first scheme, to monopolize the highway jobs, the defendants engaged, again, in classic bid rigging. For example, Daniel Staniger and his sister Karen Staniger agreed to submit so-called competing applications on behalf of their respective companies for these highway jobs. D&D Auto and Towerific were their respective companies for the rights to service the same highway segments in order to increase the odds that one of their companies would be awarded the contract. And once again, this is about the appearance of competition, but in reality, competition doesn't exist. In a third category of schemes alleged today, the defendants enriched themselves substantially through insurance fraud, involving auto body repair shops and storage yards that they controlled. Now, in these schemes, the defendants stole hundreds of thousands of dollars from insurance companies by charging for damage the defendants themselves caused to a vehicle after it was removed to the collision site, a scheme they called damage enhancement. Other insurance frauds charged today against these defendants are frauds relating to claiming they performed repairs that were never actually done on vehicles, replacing parts on those vehicles that did not need to be replaced, billing insurance companies for new vehicle parts that were actually used or recycled vehicle parts provided by the defendants, and claiming that vehicles were towed to and from various locations when, in fact, those trips actually never occurred. Finally, the defendants, several of them, are charged with good old-fashioned tax fraud. After all, they were pulling millions of dollars out by maintaining an illegal, strong grip on the towing industry and exercising influence in a myriad ways and not paying tax on the monies that they were receiving. The monies received by the insurance companies were then often taken to check cashers so they could be converted into cash, and the money could be distributed through classic structuring and not linked back to the Staniger business. So after today's announcement, I think it's safe to say that this is an opportunity for New York City to turn the page and have a new day for this industry in New York. Today, the defendants are being arraigned throughout the day before Judge Conviser in Part 95, 111 Center Street on the 6th floor. Now, our office is also today filing a civil action against the defendants to seize $20 million in illegal gains from claimed checks to the body shops and proceeds associated with those schemes. In order to ensure fair competition and encourage entrepreneurs to set up shops in New York City, we can't allow this type of systemic fraud and abuse to persist within any industry in this city. Now, our city is constantly changing, and that may be the case and always the case. And we may think we live in an era when technology, open data, and civic engagement, media scrutiny, and government reforms have made this type of industry-wide fraud impossible. But in certain industries, as in this industry, pervasive corruption still exists, harkening back to a different, darker time and era. These are the types of cases, this case that we did today, these cases are cases that our Rackets Bureau that was created 100 years ago was designed to do. And the Bureau is not going away anywhere soon. So if anyone else is planning to engage in corruption of the tow industry or other related industries, I just want to say that the Rackets Bureau will be there to turn over every stone they can find in order to shut down illegal enterprises that are creating an unlevel playing field for business in New York City. So I'd like to thank again our partners here for the great work they've done and introduce Commissioner Mark Peters, Commissioner for the Department of Investigation, for his remarks, and thank him for the substantial contribution that he has given to this case, his staff has, and to so many other cases where we've been privileged to work together.
Thank you. Thank you, DA Vance. I want to thank Chief McCarthy of the NYPD It's always great to partner with both of your offices and work on these important cases. DOI was pleased to be able to bring to this investigation our ability as the city's Inspector General to provide access to city records and a deep knowledge of how the city operates. In this investigation, the records obtained from the Department of Consumer Affairs helped investigators drill down on the false information that was being submitted to the city and the type of fraud these defendants are now charged with committing. The Department of Consumer Affairs' purpose is to protect the public from deceptive business practices, and indeed, it was the first municipal agency of its kind created in this country. As charged, these defendants sought to undermine that legacy and that purpose. Many DOI investigations focus on the issue that's been brought to light in this case, filing false information with the City of New York. False filings matter. When the city is fed false information that then becomes part of its permanent record, it undermines the city's ability to do its job and protect New Yorkers. DOI has seen stark results of this type of conduct, and often we've exposed these cases as part of our partnership with the Manhattan District Attorney. These false filing cases have led to the evasion of safety laws, to the exposure of hazardous substances like asbestos, to improper work at construction sites, and to fraud that steals taxpayer dollars. Stemming from this investigation and working with our partners, DOI will be issuing 4 recommendations to the city's Department of Consumer Affairs. 1, the city should review and strengthen the licensing system for towing companies. 2, the city should provide additional resources to the Consumer Affairs licensing and enforcement divisions for hiring and training of additional personnel to increase the frequency of inspections. 3, DCA should conduct more thorough background investigations of tow truck companies, owners and employees, and should be using a larger complement of investigative databases to conduct these investigations. And 4, the Consumer Affairs Department should ensure that data on violations, fines, and other adverse information is readily available and accessible to the public through a link on its website to the city's open data portal. Once again, we've seen that false information erodes integrity and safety, that it places New Yorkers in dangerous situations, and that it saps the public's confidence in government. DOI, working with our law enforcement partners, will not let this happen. I want to thank the team at DOI, specifically Special Investigator Anastasia Plakas, First Deputy Inspector General Mary Koslow, DCA Inspector General Chin Ho Chang, under the supervision of Associate Commissioner Andrew Brunsden, Deputy Commissioner and Chief of Investigations Susan Lambiase, and First Deputy Commissioner Leslie Brovner. Thank you very much.
Thanks, Mark. Chief McCarthy.
Good afternoon. I'd like to thank the District Attorney and his personnel for assisting and collaborating on this investigation. He gave an excellent synopsis of what we undertook together. And just in closing, I'd like to take a moment to really thank the lieutenant and team of detectives in the Criminal Enterprise Division who did a great job on this case. Thank you.
Thanks, Chief. So we'll be happy to take some on-topic questions. Yeah.
This was going on for well over 2 years, it sounds like. How was nobody watched this sooner and letting you know if they were the victim of this or seeing this?
We received information from the NYPD that they became aware of fraudulent invoices, and I think that's what keyed the investigation to get started in the time period that it did. Unfortunately, not soon enough, but ultimately successfully. Any other questions on topic? Yeah. Sure. This is on one of the applications from the companies, signed or related companies, to be in line to get a license in order to do towing, was listed as an active tow yard. And in fact, it's nothing but grass and no vehicles whatsoever. And one of the incidences involves Detective Jaime Bautista. You can see he's carrying a bat, and this relates to the allegations of the use of force to intimidate competitors away from specific jobs. And on the far right, you can see a red car, a red truck, which has been struck in practice of what they call crashing or blasting. And that is simply if a competitor gets there before you to one of these heavy tow jobs, one of the methods used to intimidate the competition and get them to leave was to essentially push your crane and crash into his or her truck. No, not all the employees are defendants of Daniel. There are Carl Fava is not an employee of Daniel. Excuse me? I apologize. Might come with you here. There are a number of defendants who are not employed by Steiniger, but that are involved in the overall conspiracy involved. Carl Fava being one of them, a lawyer.
You have Norman Tytler,
Norman Tytler, a lawyer who was relied upon to help put in the paperwork and make it appear as if everything was legitimate, when in fact it wasn't. Fava had an unusual role in that he was really acting as a mediator over disputes between Daniger and other folks who were trying to do business in potentially competing zones or highways. And when there was that kind of disagreement, they would go to Fava. Steiniger is alleged to be paying Fava several $1,000s a week in order to mediate these disputes and to pad money in Fava's bank account. And Fava was essentially the godfather who made the decisions. You're going to take this, you're going to take that, and then that's how it was resolved. So there are several individuals who were not working directly for Steiniger, but were involved in the monopolization conspiracy and in a number of the indictments. Yeah.
Is there a portion of the towing industry in New York City that doesn't include these folks?
Yes, there is. It's not as. Yes, I'll let the chief. Perhaps you can.
Yes. Thank you, Mr. District Attorney. There is, and one of the really good things that developed from this investigation is our understanding of the industry, that we'll be able to cooperate with other city agencies as well as within the department to make recommendations to continue improving what we learned in our 2-year investigation. And all of that will be put forward, and all of it can't be discussed today as the investigation is ongoing.
But I think it's safe to say that there weren't enough competitors who were able to actually compete. And the hope, obviously, with this indictment is that it will actually introduce real, full, and fair competition, managed by the Department of Consumer Affairs and overseen by Mark Peters, to make sure that what happened, that has happened, and has put so many millions of dollars into the pockets of these individuals dealing with one of our city's major industries, but one of the things that every big city has to have a large presence in, that will actually have legitimate competition going forward, which is important. Yes, sir. I'll turn to the city.
So part of what we're now recommending to Consumer Affairs is that the various databases that are available all get linked so that the next time around that's not going to slip through. That's precisely what we're recommending. It was the prior run-in was a long time ago. The databases didn't link up. Now that's what we're recommending to them that they do. That's from city records. That's city records.
It's eons ago.
Yeah, city records. That's a long time ago.
But obviously, that's something that the city wants to tighten up and does not want to have happen again, and nor do we. Any other on-topic questions? Yes, sir.
Make sure we're clear up. talking about mafia here? Are we talking about organized crime in the class of sense?
There is an organized crime element to the case, and it does center on who gets to decide what territory goes to whom. And I think that's about as much as I can say about it at this time.
Can you say whether there was any other kind of criminal activity that were involved?
This is not enough? Not that we're prepared to indict, but in this case, this is an ongoing investigation. And we really are covering monopolization, attempted monopolization, insurance fraud, tax fraud, enterprise corruption, which is the principal count against the principal defendants, which is a Class B felony. So there are 4 indictments with a number of types of criminal offenses in them, but are all really related essentially to fraud and the use of force in enforcing their ability to obtain a territory for the trucks. All right, ladies and gentlemen, thank you so much for taking the time. I appreciate it.